Litigation process starts with a letter or a complaint with the sheriff or coming to your door and saying, I have something to hand to you. The sheriff may come, or it may be a private subpoena server. Private subpoena servers, I think, are at least give a little bit more dignity to the process rather than sheriff with the gun. In a litigation process, maybe a sheriff even shows up where you're working. You're served with a complaint for divorce. You have 35 days. You have to file and answer that complaint. You're now in the court system. You're going to see a case management conference occur. That means you have to fill out a form stating when you're going to file information relating to your finances, when you're going to ask the other party questions under oath that are written, when you're going to ask the party questions under oath in maybe a deposition, when you're going to get certain appraisals. That form, you could sit in court 4 hours to fill out a form that should take you 5 minutes, and quite frankly, what we discuss in the collaborative case takes us 10 minutes maybe to discuss. After your case management conference, the court's going to set it down for what we call an early settlement panel hearing. That's a process by which you go to court, and there are skilled matrimonial attorneys that serve free of charge to help you resolve your case. Court system's usually bogged down. Maybe they get 10 minutes to help you. Maybe they get 20 minutes. It's a lot to digest and the part of the panelist to try to get all that resolved in 10 or 20 minutes with both attorneys and both clients. By the way, the clients have very little opportunity to speak because you can't allow them to speak and get it done in 20 minutes. The next process is, if it doesn't settle, which very often it doesn't, it goes to economic mediation, where a mediator is appointed by both attorneys to help them resolve their case. So both attorneys, both clients, and the mediator all come together to try to help resolve it. The first hour of mediation is free, and the preparation is free, the first hour of that. So the clients are paying for everything after your first hour of mediation skills. Often settles there, not all the time. If it doesn't settle there, you're going to a mandatory settlement conference with the judge, who may have some time for you or may not, depending on the day. If it doesn't settle there, then you're going to a pretrial conference where you're going to start stipulating what exhibits need to be demonstrated at trial. May settle that way because you're finally at the courthouse and you're a little afraid of what's next because you spent a lot of money, or it may not. If it doesn't settle that day, you're going to trial. The fiction is, you think you can have your case tried all together? No, it's not consecutive days. You may get 1 day in January, 1 day in March, 1 day in June, 1 day in August. And maybe you'll have your decision quickly, maybe you won't. It's a pretty long process. Beginning to end, historically, is 2 years. Some of our counties are so bogged down that it's a guarantee you won't get to trial for 2 years. And now, with the differences in how the judiciary is being almost forced to retire, some of our older, more distinguished jurists, we're probably going to see a lot less judges available to handle cases. So it may take longer.